appeal part heard in the matter of InterDigital Technology Corporation and Lenovo Group Ltd.
Yes, Mr. Abrams.
My lord, my lady, if I may just take stock of where I got to for the purpose of a launch pad for the points that I need to cover this morning. I'd submitted that the judge was right in his paragraph 184 to say that integer 1f covers any way of achieving the stated result. And we say the stated result being limiting the amount of MACD flow data that is multiplexed. And that's what I call the first construction issue. And I should add to that a reference in the judgment, which will help your lordship. So if your lordships have the judgment, which is tab 8 of the core bundle, at page 157.
Yes.
Paragraph 320, so this is the section where the judge is addressing DXX14.
Yes.
And at paragraph 320, you see in the second sentence, the judge says, however, as I pointed out above, the means required by integer 1f are means which produce a particular result, and the scenario presented in DXX14 achieves that result. Obviously, I say that's absolutely correct. The reason I'm drawing this to your attention is this, because that is obviously a reference back to paragraph 184, when he says, as I've pointed out above. So that's the construction that he's applying in this section, dealing with the DXX14.
So your point is he's not applying a different construction at this stage in his judgment. He's going back to the construction that he adopted back in 184.
And it follows from that that it is incredibly unlikely that he was applying some different construction in the intervening paragraphs. And I've explained that the reason he expressed himself the way he did was because of the specific, what I call a binary issue. Does it disclose this, yes or no, was the issue that he had to consider.
Yeah, well, you can make the same point based on 318 as well.
Indeed. It was 320 refers back to, although it doesn't say have the number 184 in it, it is obviously a reference back to 184. But my lord is absolutely right. So what this shows is that the claim is a very big, broad claim, and a broad claim means that InterDigital takes the risk of the prior art falling within it, and that's what happens in this case. Now, we've got, your lordships have hopefully got 156 and 157 open, the bundle, and I went through this showing you that DXX14 illustrates a scenario in which a system built according to the prior art would actually limit the amount of MACD data that is multiplexed, as required by integers 1f and 5f. And DXX14 shows a process by a mobile that can send at least 4 MACD data blocks because ETFC5 is supported. But because of this process, it is limited to 3 MACD data blocks, which is the amount of data allowed by the next smallest ETFC. And I drew your attention to the last question on the bottom of page 156, which uses the word limit. The UE would limit, and the witness agreed that in that scenario that the UE does limit. And so DXX14 shows an actual process of limiting down from at least 4 before you do this process to just 3. So as I say, our primary case is that the judge was absolutely right in 184, and in this section dealing with DXX14, and that's why we say the appeal should be dismissed. Now I move to InterDigital's case and what I'm addressing this morning. InterDigital's answer is to write the words, right into the claim, the words in paragraph 48 of the skeleton argument. And if I can just remind your lordships what paragraph 48 of their skeleton argument says, that's page 37 of the bundle.
Sorry, paragraph?
Page 37 of the bundle, paragraph 48.
48.
Yeah. And at the bottom of paragraph 48, my learned friends, I'm on the penultimate line. He says that the claim required this being, and now I'm quoting, specifically selecting the next smaller ETFC and moreover using its size as a limit to the multiplexing of data. And to avoid having to constantly repeat those words this morning, I'm going to call that the paragraph 48 procedure. And I submitted to you yesterday that there's simply no basis for writing the paragraph 48 procedure into the claims. InterDigital could have used those words if they'd have wanted to, but they didn't. And these words are not necessary to imply into the claim to make it intelligible or for any other reason. On the contrary, InterDigital has deliberately drafted wide claims and must take consequences.
Mr. Speck's answer is going to be that this is purposive construction.
Indeed, and my answer is it's writing words into the claim.
Yeah. The usual dispute.
The usual dispute. And in that context, when we talk purposefully, I developed this yesterday, and I'm sure you'll have this in mind. The point I stressed was that this is a patent about what appears in the air between the mobile and the base station. We talked about the air interface, also known as the radio resource or the radio interface. And it's all about making sure that what is in the air is as much useful data as possible and as little padding as possible. So given that and everybody agrees that the invention is about that, what is in the air, and we've got in our skeleton argument a selection of quotations on that topic, which my learned friend went to and embraced himself. So that's common ground. But of course, that's why we must be right, I say, because if this is an invention about what is in the air and making sure there's as little padding as possible in the air, then there's no way that one should then start construing the claim as requiring specific procedures within the mobile, as long as what is sent across the air is limited to ... then you are achieving the invention and you're getting all the benefit in that TTI. And so the claim quite rightly, properly and appropriately is broadly claims any way of ensuring that what goes across the air is limited, the amount of padding is limited as much as possible. And it would be very odd construction, we say, to say that the claim only covered a particular way of procedure inside the mobile phone of achieving that. When it's not about, this patent is not about the internals of the mobile phone. This patent is about what goes across the air and using that resource as best as possible. So my lord, of course, is right to say it's for purposes of construction. That's the purpose. That's why the purpose of construction leads to my submission. That leads to the judge's conclusion. So that's our primary case, and your lordships can simply dismiss the appeal on that basis. What I need to deal with now is the question of what happens if you accept InterDigital submission on the first construction issue, and you write the paragraph 48 procedure into the claims, or you construe the claims to include the paragraph 48 procedure, as I would say it, write it into the claims. We say there is no essentiality and no infringement in that case. And for that purpose, we start with the pleading.
And is that something that we can decide?
Well, my submission, if I may summarise where I'm going with this, I'm going to show you what our case is and tell you why we say there's no infringement. And then I'm going to show you why your lordships, that there is no, effectively, your lordships can dodge it by simply saying this hasn't been alleged. We don't have to decide it because it was never alleged that there is infringement if the paragraph 48 procedure is required. So that's the end of that. So your lordships have two ways of dealing with it. And if I may say this, I can well understand why your lordships may say this is not a relationship, may well say this is not appropriate for us to get into. The judge didn't make a decision on this because it wasn't pleaded and investigated at trial.
Well, we're not a fact-finding court.
Quite so, quite so. But I will explain to your lordship why we say there's no essentiality in infringement, but throughout that is a recognition by my side that your lordships and your ladyship are being put in a very difficult position by the fact that my learned friend is running a construction which he did not advance below, and he did not plead that there was infringement on that basis of that construction, and that's why I'm making these points. So just if you've got the supplemental bundle, just open at the index. So their statement of case on essentiality, which is where they say why the standard requires infringement of the claim, is tab 3. My learned friend took you to tab 7, which includes the text of their pleading plus our response. Because he's done that, I presume it would be more convenient to stick to what he showed you.
I think so.
Yes, but it's important that what we're not actually looking. The document I'm now going to is not the key document. The key document is the one at tab 3. And just so your lordship's got that, and your lordship and your ladyship will see the date is 10th of April 2020. The statement of case on essentiality was never amended. But we're going to tab.
Sorry, where do I get the date from?
It's in the index.
Oh, right.
But the date is not so important as the fact that this was their original pleading and it was never amended. So we're going to tab 7 to find the actual text that is now under scrutiny. Page 107. So I hope your lordships have got it. I've got it double printed so I can see 107 and 106, 108 together.
Yeah.
So, okay. Well, your lordship needs to look at 107 and 108. You have integer 1f.
Yeah.
You have the words of integer 1f in the second column, and then in the third column you've got InterDigital's case. And the case starts by quoting section 11.8.1.4 of technical specification 25.321. So that's just part of the standard. So they quote that, that first sentence, and then they say, it also states, and they quote, the selected size of the Mac EPDU shall not exceed the total of ... And then the quotation ends on page 107. You see the first quote, and then the comment or the allegation is on 108, which we've already looked at. Therefore, the size of the ETFC cannot exceed the size of the Mac DFlow data allowed by the serving and non-scheduled grants.
So Mr. Speck made the point yesterday that the quoted text at the bottom of 107 in fact doesn't include the clause of the sentence which precedes the words of the size, and that when you see the quotation in context, you can see the circumstance that was being relied upon.
Yes, it's only, in fact it does say, in the case where, it's in the case where scheduled information is included, scheduled data is included.
If you wouldn't mind, I would be grateful if you could remind us what he actually says in context.
Yes, absolutely.
Because although I recall the point, I don't recall the precise words.
Yes. My Lord may find it helpful to just turn the page a bit more, because we actually set it out twice in full context on page 110. So it's within the same integer.
Thank you.
Right at the bottom of the page.
Ah, yes, if the transmission contains any scheduled data.
Yes. Now, of course, I'm not focusing on, that's the question of whether the claim requires you to do it every TTI and not every TTI. So my learned friend says, well, we were saying, it was clear from our pleading that we were saying that there is only infringement in some TTIs and not others. And that's not a pleading point I'm taking or I've ever taken. Okay? They did say cannot, and we did read it as cannot, but they then said, no, we meant only in that particular situation. And that's not the pleading point I'm taking. The pleading point I'm taking now is that this does not say that the paragraph 48 procedure is required by the standard. So my Lord Justice Arnold is quite right that there are two potential pleading points, but I'm not taking the one that my Lord points out has some difficulties. And I never did take that point as a pleading point. But I am taking the point that this does not say or have any hint that the paragraph 48 procedure is required. And indeed, you can see from the text, let us look at 110. in fact, it probably is easier to go to the actual standard, because there's still some there are still some ellipses in the bit that's quoted. So that is tab 14 of the bundle. If you start at 208, so this is the part of the standard.
Well,
that matters.
yes, I'm sorry to interrupt you, but I'm just sort of processing what you said. And I take your point. You distinguish between the two different issues in the way that you've just explained. I understand that. But I'm still not quite clear that I understand your position on the point my Lord Justice Lewison put to you yesterday, which is that what you call the paragraph 48 procedure is a contention as to the true interpretation of the claim on a purposive construction. And one wouldn't expect necessarily to see the construction of the claim pleaded out unless there'd been a specific order to that effect. And even if there had been, it wouldn't be binding, because at the end of the day, construction is a matter of the court.
No, indeed, and if they had pleaded the words of let's say they pleaded the words of integer 1f.
Well, they do, because they're set out in
But sorry, what
in
I
the
mean
left-hand column.
What I mean is in the pleading. Sorry, if we go back to if we go back to tab 7.
Back to 107.
Yeah, 107. Well, it's 108 really.
I mean, but I appreciate you're in the middle of your answer, but let me just complete the question, because it might be relevant to me to articulate how I understand the function of this document, and you can tell me if I've got it wrong. The function of this document is to pinpoint the bits of the standard that are being relied upon, because the problem with these things is that these standards are incredibly long and complicated documents, and that's why we have orders for these statements of case, is because otherwise you're left, trying to put a fine tooth comb through a long and complicated document, and it takes forever. So it's an essential requirement that everybody knows which is the bit of the standard you're relying upon. And not in that, which bit of which standard. So you've got to identify the document, you've got to identify the particular passages you're relying upon.
Yeah, I absolutely agree with all of that, but it goes a little bit further, my lord, in that you are also required, save where no comment is required at all, to explain what it is that the standard requires you to do. And what they have made clear on page 108, or in the text which is in their pleading, which is reproduced on page 108, is that their case is no more or less than the standard provides that the size of the ETFC cannot exceed the size of the MACD flow data allowed by the serving and non-scheduled grant. So they're saying, if you
But that's a case about the standard.
Indeed.
It's not a case about the construction of the claim.
I agree with that entirely.
Yeah,
I agree with that entirely. Save, of course, that it's implicit that that is sufficient for infringement. Otherwise, the document would be a rather useless document. So it's your lordship is absolutely right. It's a statement about the standard, but it is a statement about what the standard provides. So it tells you what the argument about what the standard provides is, and it's implicit, of course, that that is sufficient for infringement. And that's the point. What is, and that's beyond, that I respectfully say is beyond doubt. It is beyond doubt that InterDigital was saying, they were saying that it was sufficient for infringement, merely that the size of the ETFC cannot exceed the size of the MACD flow data. And it's clear from this that they were not suggesting that the standard required any particular procedure, or that it was necessary for them to prove that the standard required any particular procedure in order to prove.
But you used in that sentence the word merely, and I'm not quite clear what you mean by merely. Because I mean, at one level, as I think both you and Mr. Speck have recognised, this is a debate about the level of generality in the claim. And I quite take your point that you say that the claim has a particular level of generality for good reason, and it doesn't descend to what you call the paragraph 48 procedure. I understand that point. But here we're looking at pleading, and you're trying to take a pleading point. And I'm struggling to understand how you say the question of level of generality is engaged by an assertion in the pleading about what happens in the standard, because level of generality, again, is all about claim.
Sure, but the InterDigital have said our cases that looking at the standard, they have said this is the level of generality at which we advance our case, in which we say the standard operates sufficient for us to show infringement.
So can I just make sure I've understood the point? The point is that the allegation relates to what you said about what goes over the air.
Indeed.
And if you can produce this effect otherwise than through what you call the paragraph 48 procedure, then you don't infringe because of paragraph 48, but you are compliant with the standard. And therefore the standard does not require the paragraph 48 procedure. Is that the point?
If I may just check I've understood the question. Yes, indeed. 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 And that is, we say both things. We say that the text does not, that the standard does not require the paragraph 48 procedure, that you can comply with the standard without doing the paragraph 48 procedure. And that's the technical issue which I can understand why your lordships might regard as one for the trial judge. And I say that the reason why the trial judge didn't make any finding on that is because they didn't allege that the standard requires the paragraph 48 procedure. And I was about to show you, well, that conveniently leads to the evidence on this, which is not in dispute, but it's nicely set out in tab 10 of this bundle on page 136.
So just to finish this point off, because you say the standard does not require the paragraph 48 procedure, it therefore follows that the paragraph 48 procedure cannot be described as essential.
Correct. Absolutely. Absolutely.
It's just one way of getting to what the standard requires.
Sorry, if you lordship. Yes, is the answer to your lordship's question. Yes, and I just wanted to show you that the experts dealt with that on tab 10 of this same supplemental bundle, page 136. So it's paragraph 9.18. This section, this is the section we're looking at, 11.8.1.4, does not include an explicit algorithm for ETFC selection, although Annex C, which is informational, includes a possible implementation. Rather, the section includes a list of 14 conditions on the ETFC selection process, and these are set out below. And he goes through them, and they include the one that they say has the consequence that the ETFC cannot exceed the size ... And so he's making, and this wasn't challenged. So that's confirming the point.
Sorry, which is the relevant one of the 14?
The relevant one of 14 is paragraph 9.27. Oh, sorry, it's below 9.27. It's actually commented on in 9.28. So the doctor sets out each condition and then comments on them below the quotation.
Right, but at the moment it's not jumping off to the page to me whether he agrees or disagrees with the proposition in the pleading about cannot exceed.
Well, he then goes on to say no, he disagrees in the sense it can exceed when there's non-scheduled data. That was his point. So he disagreed in that sense.
But as you've said, that's a different issue.
That is yeah, absolutely, absolutely. He didn't engage with the question of whether the standard requires the paragraph 48 procedure for the very obvious reason that nobody had suggested that the standard required the paragraph 48 procedure. He was simply engaging with the pleading that I've shown your lordships on page 108. And that really is the key point. InterDigital never ran a case at trial that to establish infringement they could show that their specific paragraph 48 procedure had to be present. And of course, we, Lenovo, never pleaded that the standard did not require the paragraph 48 procedure because there was no suggestion that it did require the paragraph 48 procedure. That's why there's no pleading from us about paragraph 48, the paragraph 48 procedure. And that's why Dr. Irvin never considered the question of whether the paragraph 48 procedure was required in any of his reports because it was never suggested. And there was just no investigation at trial about whether the standard required the paragraph 48 procedure. I certainly didn't cross-examine on that topic. I cross-examined on the issue of that we were just discussing about cannot, although by that stage the facts were no longer in dispute. And I cross-examined about some other non-infringement points which we aren't, which were rejected and we're not pursuing. You lordships can ignore. But I certainly never cross-examined about whether the standard requires the paragraph 48 procedure because that just wasn't suggested. It never, if I may say so, it never occurred to us that we had to deal with that issue because we relied on the pleading and what the pleading said. And the judge certainly didn't consider that InterDigital had advanced such a case. Otherwise, he would have considered that case in his judgment. Instead, he only made findings about essentiality on the basis of his construction, which, as we've seen, merely required a result. And if I may just make sure that we're all on the same page with regards to that. If your lordships would mind going back to the judgment, page 125 of the core bundle.
Which paragraph?
So 184 is the paragraph where he deals with the construction.
Yes.
And we know from the section on DXX14 and in particular the reference back at 320 what he means in paragraph 184. He then considers essentiality and infringement, and he says that they depend on common ground. The points on essentiality and infringement depend on and only on the 3 points of construction which I've dealt with, which obviously didn't include the paragraph 48 point. And since I've decided all of them against it, followed there's no remaining dispute. The patent's invalid is essential. So at no point did the paragraph 48 procedure enter his mind as something that he had to consider. So there is no finding that there's infringement on the paragraph 48 procedure. And why would there be, given the state of the pleadings? My lord and my lady, I now need to deal with some submissions my learned friend made about Annex C. So for this purpose, you can put the core bundle away for a moment. And please, could you go back to the supplemental bundle? Tab 10. So he shows you page 145 of the supplemental bundle.
Yes.
That is a flowchart created by Dr. Irvin to represent Annex C. The reason Dr. Irvin was relying on Annex C is because, although Annex C is merely an example, in order to disprove essentiality, you can, of course, show one example of a way of doing the standard without infringement. So where Annex C has got an example, if we can show that Annex C is outside the claim, then obviously we would win, because that would mean the claim couldn't be essential. But the converse obviously doesn't apply. Just because you show that Annex C is within the claim doesn't show that the standard is essential, because Annex C is very much expressly just one way of doing the standard. So I'm just telling you that to explain why Dr. Irvin went into Annex C in detail. Because it was a way for him to attempt to demonstrate non-essentiality. Perhaps not surprisingly, Mr. Townend didn't mention Annex C at all, and that's completely unsurprising because he was trying to explain that the patent was essential, and Annex C couldn't possibly help him on that because Annex C was just an example, so it wouldn't have helped his argument.
He might not have mentioned it in his first report, but presumably he would have commented on this in his second or his third.
Very briefly in his second to say Dr. Irvin is right, that you don't, the point that Dr. Irvin was making, he said, yes, you're right, you don't need to limit to this next small ETFC in every case. So he accepted that Dr. Irvin was right, that it's not every TTI. That was it. That was the extent of his comment on Annex C. And I don't know if he even mentioned Annex C. He mentioned this bit of evidence. He said it's very long and complicated, but the upshot is I agree. He certainly didn't attempt to show the paragraph 48 procedure in Annex C, if that's something, or anything like that. And then my friend, just to complete it, said so that's why Dr. Irvin was referring to Annex C. Of course, not considering the paragraph 48 point at all, of course. And then my learned friend showed you the cross-examination, the quotation on page 278 of the same bundle. This quotation is where my learned friend was seeking to establish that Annex C required the paragraph 48 procedure. So it's 278 and 279 is the cross-examination that my learned friend relied on. He showed you that yesterday. Sorry? And he says that establishes that in Annex C, the paragraph 48 procedure is applied. So I need to make a number of points about that. First, and obviously, Annex C is merely an informational annex. It gives an example of one way of implementing the standard, but it's not something that mobiles have to do. That's absolutely common ground. I've shown your lordships, Dr. Irvin, paragraph 9.18, and he made the point again at paragraph 9.33. And it's informational, which means it shows a possible implementation which you can use, but by no means is something you have to do. So just because, let's assume Annex C does describe paragraph 48 procedure, that doesn't mean that the standard requires a paragraph 48 procedure or that it's essential. And furthermore, and this is important, there's no allegation or evidence that my client's devices implement Annex C. It's common ground that they implement section 11.8.1.4, that's alleged and admitted. But there's no allegation, no admission, no evidence that my client's devices implement Annex C. Nor did InterDigital plead that Annex C requires the use of the paragraph 48 procedure, or rely on Annex C at all in their pleadings or in their evidence. So my Lord Justice Arnold, if I may respectfully say so, a moment ago gave an extremely helpful explanation of why these pleadings this sort of pleading is essential. And the fact that they didn't rely on Annex C in any part of their pleading means that it's just not open to them to say Annex C is relevant to this. And as I say, Mr. Townend said nothing about Annex C other than to just agree with the conclusion that Mr. Irvin drew on a completely different point. So I didn't examine Mr. Townend about Annex C at all. There was no investigation at trial about whether Annex C requires this paragraph 48 procedure. You could, lordships and my lady can imagine the course of the trial. Mr. Townend gave evidence first. I cross-examined him, and then when Dr. Irvin gave evidence, my learned friend adduced evidence relating to Annex C and the part of the cross-examination which he now relies on came out at that stage. I, of course, didn't engage with that that evidence in closing that had been extracted because there was, forgive me for repeating myself, there was no suggestion that the standard required this particular procedure, so I just wasn't something that was an issue. I had to deal with the pleaded case. And again, I've made this point, so the judge made no findings about Annex C at all, about whether my learned friend is right or wrong that it requires this particular procedure. In fact, we actually go further. It's very telling that my learned friend in this court is now relying on Annex C at this stage. By relying on Annex C, he's effectively accepting that he can't find the paragraph 48 procedure in the standard. That's why he has to look at an example implementation. I mean, it tells you all you need to know that you need to go to an example implementation. If you'd have pleaded Annex C at the beginning, I think perhaps saying that there would be a strikeout might be putting it a bit too high, but we'd immediately said, well, Annex C's got nothing to do with it. We don't do it. Well, we would have. Annex C's not part of essentiality. It doesn't help you with essentiality. The reason he's relying on Annex C is because he can't find the paragraph 48 procedure in the standard proper or in the Lenovo devices. What my learned friend said to your lordships yesterday was that the Annex C example produces the same output as what's required by the standard in the relevant section. We thought that was an extraordinary submission because the whole reason we're here is because my learned friend strongly disclaims that as being sufficient for Claim 1. His whole point is that it's not enough to be within Claim 1, that a method produces the same output as Claim 1. He says to be within Claim 1, you actually have to do the paragraph 48 procedure. So it doesn't help him to show, if it be the case, that you can produce the same output doing the paragraph 48 procedure. He has to show that the standard actually requires the paragraph 48 procedure. It can't be, an output can't be enough for his infringement case. Merely having the same output can't be the same for his infringement case, but not good enough for validity. You can't have a narrow interpretation for one and not the other. And the reason for that is because on any view, filial requires the same output as Claim 1 on some occasions. DXX14 is an example of a scenario where filial produces the same output as the standard. I mean, we say DXX14 goes further, but it clearly requires the same output as the standard. So if the same output is enough for infringement, then it's obviously enough for anticipation. So the fact that in the context of infringement, my learned friend is driven to rely on bits of the standard which aren't things that you have to do, things which he hasn't pleaded, things which he hasn't shown that or alleged that my clients do, and the fact that for infringement he has to rely on a construction that merely producing the same output as Claim 1 is enough, that tells you everything you need to know about the infringement case. The fact is he can't point to anything in the standard that requires the paragraph 48 procedure, and it just simply wasn't an issue in trial. So, my lord, that is what I wanted to say about infringement essentiality, if there's anything else. At the end of my skeleton argument, we address Claim 5, but I think the lordships have all the points on that. We don't disagree that the lordships can look at Claim 5 when construing Claim 1, and of course we say it has the same material scope. Just to make sure that I've made myself clear on that, in relation to the first construction issue, Claim 5 covers the step of, Claim 5 includes a step of limiting the MACD data, but that covers any way in which the data can be limited. DXX14 shows the data being limited in the way required by Claim 5 integer f. So the method disclosed in filial includes the step of limiting as per integer f. So, in conclusion, our primary submission is that the judge was right in his claim construction, that the means for limiting means adapted to achieve the result that the data is limited, and the judge was right, and so was Mr. Townend for that matter, to say that DXX14 showed exactly the limiting required by the claim taking place, and therefore Filatrao disclosed a system.
Can I just go to your skeleton argument for a moment?
Yes.
You start the procedural point at paragraph 36 on page 54.
Yes.
And you say in your Roman 3 that you would have adduced evidence and directed argument to the consequences for essentiality infringement on the basis of this paragraph 48 procedure.
Yeah.
Well, you've addressed argument, that I understand. What evidence do you say you would have adduced,
yes,
had this point been clearly articulated?
I will answer.
As I said to you yesterday,
No,
I think that's really your only point on procedure and claim 5, as I see it.
Yes, I understand. Well, there are a number of aspects here. Just to make myself clear, in 36.3, we're talking about evidence directed to the construction issue. The evidence directed to the infringement issue, which is what I've dealt with.
Yeah.
Obviously, Dr. Irving would have addressed head-on the question about whether or not the standard requires the paragraph 48 procedure. That's which he just didn't address at all. Here, I'm talking about evidence related to the question of construction as to whether or not Claim 1 requires the paragraph 48 procedure.
Oh, I thought you were talking about the consequences for essentiality and infringement.
Right. Okay. So let me say what we would have done in relation to construction. There would have been more focus on the matters particularly addressed in paragraphs 24, 25, and 26 and 27 of the patent. Now, I think actually, in fact, paragraph 26 is such common ground that perhaps that's fallen away because everyone agrees that the patent is directed at what goes over the air. So that being common ground, I don't need any more than that. In relation to 24, Dr. Irving did make the point in relation to the specific standard that it talks about conditions and not a particular algorithm. But it would have been appropriate for Dr. Irving to talk more generally about standards and to say about how standards generally are focused on results, and that would therefore be something that a skilled reader would have in their mind when reading a patent. So that's the point on construction. When it comes to infringement, as I've said, then there would have been a very substantial amount of evidence from Dr. Irving dealing directly with whether or not the standard required the paragraph 48 procedure, other ways in which the conditions that he talks about could have been satisfied without using the paragraph 48 procedure, and dealing head-on with that. As your lordships have been spared the vast amounts of Dr. Irving's evidence describing various aspects of the standard in order to show that, as a matter of fact, our other non-infringement arguments were right. Now, those other non-infringement arguments were rejected as a matter of claim construction. But it was accepted that his explanation that this is how it works, this is what the standard requires, that was all accepted and it was gone into great detail. So there would have been another section saying, now I'm going to address the allegation that now I'm going to address the section that the allegation that the standard requires the paragraph 48 construction, and here it is. And I can't tell you what that would have contained, but I can tell you what he would have been asked by the solicitors. He would have been asked to consider by the solicitors, firstly, does it require it? Secondly, can you explain other ways in which the conditions in the standard could have been complied with without using that particular procedure that they say the standard requires?
Yeah.
And I don't know what he would have said, because that just wasn't an issue that I ever had to discuss with him, and nor did I ever have to discuss it with Mr. Townend, or think that I had to discuss it with Mr. Townend. Oh, excuse me. I hope it was clear from context. When your lordship asked me about what evidence, I said evidence relating to paragraphs 24 to 27. I might have said paragraphs 24 to 7 of the patent. Yeah. I did, but skeleton.
No, of your skeleton.
Of your skeleton.
That's what I understood.
Thank you, my lord, and thank you. Yes, thank you. So that was that's the answer to your lordship's question. And unless you've got any other questions, those are the reasons why we say the appeal should be dismissed.
Thank you very much, Mr. Abrams. Mr. Speck, any reply?
Got about half an hour.
Yes.
My lady, my learned friend Skeleton starts by setting out a lengthy section advancing an argument that means for in the claims are construed as suitable for. He stood up yesterday afternoon and it turned out that was not his case. My learned friend Skeleton begins its section on construction of Claim 1 by introducing what it said were three constructions before the court: the judge's construction, Lenovo's construction and InterDigital's construction. He stood up yesterday afternoon and resiled from that too, preferring to say there were two separate construction points, as I understood him, suggesting each could be resolved in two ways, logically I think making four constructions, although I have to confess to not fully grasping what they were. One thing I did understand was that the constructions now on the table from my learned friend did not equate to those put forward in his skeleton. For example, the so-called judge's construction identified in paragraph 16 relied upon and incorporated the suitable for point that Mr. Abrams didn't seek to support at all. His skeleton argument argued at paragraph 17 that my case at trial had been what he identified as the judge's construction. On this point, what my case at trial had been, we knew at least one contention would have to be dropped because, as I pointed out in my submission, his skeleton was not even consistent. But the case changed even further on what he says is the judge's construction, more than simply dropping the suitable for point. It's tolerably clear from his skeleton that the construction he was aiming for in that skeleton, as the judge's construction, was one simply where means were able to produce the result of an ETFC larger than the sum of the grants being not used. Of course, his skeleton uses the word limit from time to time, but that sheds no light on what he's intending it to mean because it is the very word in the claim itself. But there are bits of his skeleton that would just never have been written if this new judge's construction were his case. For example, that paragraph 26 that we looked at, 27, 26 and 27 read together, but it's 27, where his target for what he says the claim covers is plainly simply arriving at the result that an ETFC larger than the sum of the grants is not used. My lords and my lady, just look at that, right at the end. Target, what he's arguing for as being covered by the claim, is simply arriving at the result. It's also inexplicable that he suggests that should suggest that the judge's construction didn't mean really limiting. You may recall that was his paragraph 18 where he tried to say, well, his construction limiting really meant limiting. He would never have said that if his construction was what we hear now. So when he stood up, his submission as to the construction the judge applied was not what we saw in his skeleton argument. It had changed. And
you're making these points because?
Well, I'm going to explain what the construction is that you're now meeting, we're now dealing with.
And we've got to decide what this claim means.
Sure. And I have to address a different construction to the one I was addressing in opening the appeal. And I'm going to identify what it is very carefully and explain why it's wrong. But I have to make the point to my lords and my lady that it's a different construction and identify how it is different. Right. And what he was saying is that it involved the step, and let me just say this. His argument has changed. And now it all hinged on an argument that the ETFCs shown in DXX14 were those that passed through the ETFC restriction process. You remember that and how he made a song and dance about that. The argument being that there is a bigger ETFC available that's not used. Crucial part of the argument, but not mentioned anywhere in his skeleton, as my Lord Justice Arnold was very alive to. It's not surprising he made no mention in his skeleton because it's just different to the argument in his skeleton. What this new argument as to what the judge's construction amounts to is grasping at the grants grasping at the grants applicable to individual categories which result in a multiplex body of data of a particular size. And because each individual grant restricts the quantity for that category, it is that feature, those separate allocations per category, that's being relied upon. That's what causes the multiplex data to be the size it is. If my friend was actually asked, what is the step of limiting on this new construction, his answer would be the application of the grants collectively, and his answer in respect of the means he was relying upon for Claim 1 would be the program logic that gave effect to the grants. It would have to be that answer. So just to be clear, the case now advanced orally is that the judge's construction does really limit in accordance with the claim because the data is subject to rules of grants individually. And the problem for my friend, though, is the wording of the claim requires the MACD flow data multiplexed into the PDU to be limited to the next smaller ETFC size. Limited to. My friend's construction ignores the clear indication that what is required is just not some limitation that occasionally results in a body of multiplex data under a particular size, but requires the limitation to the particular size. My friend says I'm writing words into the claim when I say that it requires the ETFC size to be used as the limit. That, with respect, is not true. It's an advocate's favourite trick to say when an opponent explains what they say the words in the claim mean, they riposte, but you haven't said that in the claim. The words in the claim do say limit to the
So
next.
let's just get the claim in front of us, shall we?
Oh.
It's always helpful when
It
having
is.
these discussions to have the wording. So we can take it anywhere, but I've got it in your skeleton argument. It's as good a place as anywhere.
Oh, okay, well, I'll... So I'm looking at the way we've set it out in our skeleton in paragraph 33, which is, I think, where Arnold has it. Means for limiting MACD flow data multiplexed into PDU to a largest ETFC size. That is smaller. So that's basically, you can paraphrase that as means to limit the MACD flow data multiplexed into the PDU to the next smallest ETFC size. Limiting to. So there are words in the claim that I'm giving meaning to. I'm not writing words in. And it's funny how often an advocate who's particularly vulnerable on his own submissions as to construction feels the need to say, you're writing words in. It's a submission you should treat with caution, made by my learned friend there, although it does have its place, as you will appreciate when you consider the suggestion that the claim should be construed as meaning it must be applied every TTI without exception. But I'm not writing words into the claim. I'm telling my lords and my lady what limiting to the next smaller ETFC size means. So, just to be absolutely clear, the issue between us, now that my friend has stood up and advanced a different construction, is on his oral submissions, it's narrowed a smidge. Unlike what he was saying in his skeleton, for example at paragraph 27, the patentee would not have been understood to cover anything where an ETFC larger than the sum of the grants is not used, simply because of that. His case now is that there is some form of limitation and sometimes an ETFC larger than the sum of the grants is not used. That's his construction now. The trouble for my friend is that on his new version of the judge's construction, there's just simply no nexus between the process of limitation and the ETFC size of the claim. Whereas what I say to my lords and my ladies is the claim requires means to limit to that particular ETFC size. The point in a nutshell is my friend's new attempt at the judge's construction accepts there's got to be limitation, but doesn't require that ETFC size to be used as the limit. How can it sensibly be said that the multiplex data is limited to that next smaller ETFC size? Put it another way, the argument divorces the limit to be applied from the act of having some kind of process that has a limiting effect. And what he does is he argues that if there's some other limiting effect, in this case from the grants, and the end result is a multiplex body of data that is in fact smaller than the next smaller ETFC on occasion, there has been a limit of the multiplex data to that next smaller ETFC size. That's his argument. But please note this well. The body of multiplex data that may be arrived at on occasion is also smaller than other things that are unrelated to the limit that you've applied to get there. Smaller than the ETFC that's the next bigger than the sum of the grants. And the next one, I could go on. You can pick anything that's in fact bigger and say what my friend says in respect of the next smaller. It's been limited and it turns out to be smaller than something which is bigger. But it's not been limited by anything in any sensible way in which you could say it's been limited to. If the size of the thing doesn't actually have to be used as a limit, which is my friend's new oral argument, but all we need is some unrelated limiting effect, an end result, DXX14 not only shows limitation of the multiplex data to the next smaller ETFC size, it equally shows limiting the multiplex data to the sum of the grants, to the next bigger ETFC size, to the one bigger than that. It shows I can substitute next smaller ETFC. I could put anything in there that's bigger and say that DXX14 shows limitation to, and then just identify anything that's bigger. That's his case.
So it's like being just able to walk under the bar at the fairground.
Oh, my lady's ruined a point I was going to make later.
Sorry.
But absolutely. Absolutely. Yeah. The point being, you've got a limit of 6 foot. Somebody that's 4'11" walks under. You did limit at 6 foot. And you turn around and say, well, I've limited it to 5 foot. Because somebody under 5 foot's in there. I could pick any other bar, but my lady's got the point exactly. How do you look at DXX14 and decide that the thing to say is that the multiplex data has been limited to the next smaller ETFC size, rather than anything else that's bigger? Say the next bigger ETFC size, the one that's bigger than the sum of the grants. Neither has been used as the limit. The effect has come from the grants. Yet my friend says in this new version of the judge's construction that this is the multiplex data being limited to the next smaller ETFC size. It's not. And that is no doubt why, in that passage of cross-examination I showed you, that was quoted by the judge, Mr. Abrahams didn't put the question like that at all. He preferred to ask if it had been limited within the next smaller ETFC size. That question right at the end of the judge's judgment, sorry, that quotation of cross-examination.
Paragraph 317.
Yes,
at page
limited
156.
within.
Yeah.
Limited within. The question, that same question could likewise have been put, that it had been limited within the ETFC size that's one bigger than the sum of the grants. And the answer would have been yes. That's why that question was put that way. And having listened to his oral version of the judge's construction, I was left wondering why he didn't have the courage to put the point as limiting to the next smaller ETFC size. We say you need to use the ETFC as a limit. That's why you need to identify it earlier, because you're using it as a limit, as the judge held was required, so that it can be used in multiplexing. And we'll come on to it, as my friend's expert fully understood.
Right, well, before we get on to that, you've mentioned an important point, and I think I'd like to tease that out. And let me see if I've understood your argument correctly. You say that when you talk about identifying the next smaller ETFC, you're not saying that there's explicit language in the claim about that. You're saying that is the effect of the language that is there.
Yeah, it's the effect.
Because that's how you do it.
You can't use it as a limit if you don't know what it is yet.
Yeah. To use it as a limit, you have to identify.
That's exactly the point.
Implicit.
And that's absolutely the point in Dr. Irvine's summary of what the claim requires. You remember we set it out, I think, in paragraph 40 of our skeleton. He's not saying you do it because it's not 40. Might be, I'm looking at the reply skeleton. He's not saying you do it just for the sake of it. And the reason the judge is identifying it as earlier is because the key thing that happened previously is you did your multiplexing and then you looked for an ETFC afterwards. The key thing about the invention is you've got to use an ETFC size as a limit in multiplexing. So that requires you to identify it earlier. And yes, it was paragraph 40. I just picked up the wrong skeleton. So paragraph 40 of our skeleton has that summary of what the claim requires in Dr. Irvine's view. And this is quite important when we come back to my friend's point about infringement, because Dr. Irvine was absolutely plain. You've got to, the first two steps are about identifying the relevant ETFC size. And obviously, because the ETFC size has to be next smaller to the sum of the grants, the first thing is, what's the sum of the grants? That's paragraph 8.38.1. So identify the sum of the grants. Next one, identify the largest ETFC that's smaller. So that's basically identifying the next smaller ETFC. Third step, limit the MACD flow data to fit into this ETFC size. It's describing taking the sum of the grants, identifying the identifying the ETFC size and using it as a limit. And it is, as my Lord Justice Arnold said, my response would be, it is a perfectly legitimate and straightforward exercise in purposive construction. And don't forget what the purpose is. I tried to emphasize it yesterday. The purpose is to ensure that a larger ETFC than the next smallest is not used. That was agreed by my friend in his skeleton. That is the purpose of it. You do it by identifying the thing that you're making sure is not exceeded and using it as a limit. So, to summarise, my friend's construction has changed to accept that some aspect of limitation is required, but he says it doesn't have to have anything to do with the ETFC size in the claim. We say it does. That is the fight between us. Can I address another quite remarkable aspect of my friend's submissions yesterday that relate to that? He said nobody on his side ever had any idea we were saying the ETFC of the claim was actually used as a limit. There were several points of my friend's submissions which we were frankly astonished at. First is this. He suggested that when the judge said it was a requirement of the patent regime to have a step shown in the right-hand side of X3. Remember that earlier step, which is you have to do if you're going to use it in the multiplexing. It's actually used in the next step in the right-hand side in the multiplexing step. When the judge identified that and said it was a requirement of the patent regime, and when the judge gave that as a reason, its absence as a reason for concluding there was no anticipation, the suggestion my friend made yesterday was the judge was really talking not about the patent regime as claimed, but according to some specific example. But he never sought to identify which one or why the judge would have been concerned with that. But that's his attempt. It's an important part of his submission to say that this just wasn't on anyone's radar.
This is the paragraph 195B point.
It's the 195B and then the subsequent finding that it's not anticipated because it's not present.
Yeah, that feeds through to 199C.
Absolutely.
And then through to the
absolutely.
answer.
Yeah, and the explanation there was
300C.
Yeah, because when you just look at the text there, it's obvious that the judge is considering a construction that requires the ETFC size to be used as a limit. And just to be clear, that's all that my friend means when he says the paragraph 48 procedure. He likes to say it's a procedure like that, and no doubt he likes to say that describe it like that to try to make it sound as if there's something substantial going on. But that's all he means. And the text in the judgment is absolutely clear that the judge is saying that it's required and its absence is the reason Filiotrove didn't anticipate. And my friend's only answer is, oh, well, the judge didn't actually say the claim, he said the patented regime. He must have been talking about some specific example. Next, he sought to suggest that Dr. Irvine had given that very clear explanation of what the claim required and expressly said all his evidence was given on that understanding, somehow mistakenly and not really meaning it. It was suggested he was seeking to explain the claim directed to other issues. Well, my lords and my lady, that just won't do. His summary of what he understood the claim to require was as clear as one can get, and in fact only really concerned the role the ETFC size had to play. We've just been to it.
How does that help us?
Well, it's important on my friend's suggestion that none of this was in play and that somehow there's a lacuna at what was discussed or what was debated at trial that's my fault. This was all in play. They knew what the construction of the claim was. It was agreed, and they identified what their non-infringement points were. Yeah. It's really important to that submission. We've just been to the extract that we set out in paragraph 40 of our skeleton. It focuses on identifying the ETFC, separates that out into two steps, because you've got to add up the grants first and then identify the ETFC. And the third one is using it as the limit. But according to the submission that my friend makes, not intended to be treating the claim as requiring the ETFC size to be identified and used as a limit. All a mistake. As I understand it, not only by Dr. Irvine, but all of the galaxy of talent in the legal team on the other side, none of them ever thought the claim required the ETFC size to actually be used in the limit. My lords, my lady, it's fantastical, particularly when one takes account of the fact that my friend didn't deal with the passage of cross-examination where we saw myself and Dr. Irvine agreeing the same thing. Don't forget, my lords and my lady, this is being suggested, this is a new point on this appeal. Yet they managed to put in evidence that expressly and clearly said exactly the construction I rely upon is right. They sat and listened to myself and their expert agree that it was right. We had a debate about whether filiatro anticipated focus on whether the step was present, and the judge even held that it was so. Yet my learned friend stood up yesterday, said this is new on the appeal. It just never occurred to anyone on their side before. That brings me to the attempt to say it's somehow linked to our pleading because they thought the case we advanced was of an absolute rule that applied every single TTI. First point to make about that is that there's no logic to why, even if he thought our case was that there must be no possibility of exception of application of the step in every TTI, one would think that therefore the ETFC size need not be used as the limit. But as I understand it, that's part of his submission. There's no logic to that. My friend sought to say that the words in our essentiality pleading caused them to think our case was that there can be no exception in any TTI. But as I showed you, the words relied upon are prefaced in the standard by the making it plain that it's only when scheduled data is included. And as you saw this morning, not only is it clear in the standard, we actually did set it out in full further on in the very pleading that we were looking at. My learned friend showed you at my invitation us setting it out at pages 110 and 111 of tab 7 of the bundle. That relates to integer 1f. I could just add it was included again in integer for claim 3, that's at page 113, same text with the qualification, page 114 for claim 4. It's there again and again. It doesn't stop there, my lords and my lady, because the idea that my friends thought we were running a case adopting a construction that the rule had to be applied every TTI is completely untenable when you look at the opening submissions. You will recall that I explained that the extract selected by my friend didn't support the submission that we were running a case that was the judge's construction, and I threw down the challenge to my friend to go to it to support the argument, which he didn't. But the same sections of our opening show that we weren't running a case requiring the rule to be applied every TTI.
Sorry, if I can help my friend, I hope I didn't ever suggest that by the time of trial we thought that he was running can never exceed. So that's not a point I was ever seeking to suggest to your lordships. By trial they've made that position clear. I completely accept that, so you don't have to do with that.
Let me just give my lords and my lady the reference then, rather than taking time to turn it up. It's tab 15 of the bundle, are opening submissions, and you can just, for instance, look at 242, at the foot of 215, over the page to 243.
Yeah, it's 242 you're making that point.
Yeah, and we go over the page. If you look at 243, we make the point that there's common ground that the multiplexing limit is not applied all the time. We thought it was, maybe it wasn't, but it's our case. Now, can I move on to add to the submissions I've just made about Dr. Irvine well understanding that the claims require the ETFC to be identified and used as a limit. I showed you aspects of that evidence in opening, and I also showed you the evidence he gave about Annex C. Given what my friend has said about essentiality not being addressed on the correct basis, what I also want to show you is Dr. Irvine doing exactly what my friend said was not done. You'll recall we looked at extracts from his report in tab 10. We were, in particular, we looked at the diagram in 145. My friend went to some this morning, but can I ask you to just turn a couple of pages forward from 145 to 148. Para 9.53, he's explaining what happens in the grant limited case, which is the one where there are ETFCs larger than the sum of the grant, which everyone agrees is what the patent is directed to. And Dr. Irvine is quite clear, if there is scheduled data sent, so recognising the qualification.
He's talking here about the standard, is he?
Yep.
No, this is Annex C, my lord.
Annex C.
Talking about what happens. We'll go to when he looks at essentiality in just a minute. If you look down below at 9.54, again, he's identifying, he's focusing on the situation where both scheduled and non-scheduled data is transmitted. He knew that that was our case. As an aside, my friend sort of gives some evidence about how, in his view, my client somehow failed to get their proposal adopted and are massaging a patent to cover the standard to do something different. As far as I could understand him, his point, shorn of all the rhetoric, was simply that our quantization proposal was adopted for use in all mobiles, save on the occasion when they're transmitting only non-scheduled data. That's his point. That doesn't mean we failed to get it adopted. It was adopted, but just not adopted for that particular case. Can I ask my lords and my ladies to turn the page? Essentiality. See the heading. And remember, please, that Dr. Irvine is giving his evidence on the understanding he set out earlier that we've seen as to what the claim required. He's giving his evidence on the basis that the claim requires the ETFC size to be identified and used as a limit. Para 956 explains a point I mentioned earlier. The patent is concerned with the grant limited case, uncontentious. But look, please, at 957. He explains that claim 1 requires the MACD flow data is limited to the largest ETFC smaller than the grants. And we know what he understood that to mean. He says this is similar to that used in the standards that he's just explained, and he goes on to raise two differences. The remainder of 9.57 is Lenovo's point on where there's an exact matching ETFC, suggesting the claim required the mobile not to use it. That point was rejected by the judge, but that's one of his differences. Para 9.58, it suggested that the patent did not take account of headers, whereas the standards did. That's a rather perverse point, because it ended up basically counting data that wasn't the amount that mattered. Again, rejected. Those are the 2 points that he identifies as the difference. We simply can't see how my friend stands before the court and argues that we're raising something for the first time in this court that had not entered their heads. We simply can't see how they can say that they didn't realise the claim required this, and they would have tried to run a non-infringement point in addition to these.
So I understand your point about 957 and 958. What do you say to the argument that Annex C doesn't help you because it's an optional implementation?
Right. That really rather depends. I'd understood where Dr. Irvine to be saying that it provides an equivalent, that he's talking about doing more than my friend says. If my friend is right, that it simply gives you an ETFC of a particular size, then he's right about that, because it's an example. He's right about that. But the evidence that I pointed to in my submission went further than that, was saying basically it has to do this. But he's right that Annex C on its own, if there's another way of doing it, wouldn't be enough. The real thing, my lord, is this. If you've got to ensure that something is not, you've got to ensure that the limit is applied so that an ETFC larger isn't used. What is it that you do that isn't apply it as the limit? And the point that I make forensically is Dr. Irvine knew or understood the claim required it, and the non-infringement points he could identify did not include a suggestion that you wouldn't apply it as a limit. And let me add this. The function of those statements of case, definitely, as my lord said, to identify the documents and the particular passages, definitely, as my friend said, to give a bit of guidance. But also, the reason that we have one that has an extra column with their answer is to identify the positive points that we have to focus on at trial. It's as much about that as about what we're doing.
His point on essentiality, though, is there isn't a particular method required for guaranteeing or for producing the output. Yours is one. There could be others.
What others? And my point is this. That
so you say that if you're going to say there are others, you'd have to show what they are.
Well, at least some suggestion, but also my point is, it's not even that. They would have had to have raised the point back then because everyone knew that we were proceeding on the basis that that's what the claim meant. Their expert explained it. He would have identified a point and said, hang on a minute, you don't actually have to do this for this reason. His construction is the thing that we're relying upon, that you have to apply the ETFC size as the limit. He says he understands it. He then says there are two differences. There are two differences which are not anything to do with what we're arguing about, and he never mentions that there might be some other thing that you could do. And that's the whole
just to go back to your fairground example, the required output is that nobody who is taller than 5'6", whatever it is, goes on the ride.
Ensuring it.
Ensuring it. And you say, well, we're putting up a bar. You've got to be able to walk under the bar in order to get on the ride.
Yeah.
And if somebody else said, well, I'm going to measure everybody who wants to get into the fairground at all, and I'm not going to let anybody into the fairground unless they're under the required height, that would be a different way of producing the required output.
Maybe, although it depends what level of generality you're looking at, because you're measuring everyone's height. So, I mean, if the point is simply a height restriction, if at 6 foot or 5'6" or whatever my lord said, then if the claim's pitched at the level of generality, the height restriction of 5'6", then it wouldn't matter where you put it, just on the fairground ride or in the fairground entrance. So I understand the point that my lord's putting to me, but really the fundamental point is this. They've come to court when it's plain on the materials that their expert understood the claim to mean what we say it means, where we've had a procedure where there's an onus on both sides to raise their positive points. That pleading is there for both sides to raise their positive points, and their expert never did it, and they didn't. It's just inexplicable that Dr. Irvine understood the claim to mean that you use the ETFC size as a limit, but then didn't say there's some way of doing something different, like moving the bar somewhere else, and that's a different thing. Yeah. Can I end on a point that not so much an answer to something he's made, a point that he's made, but what he didn't really deal with, dealt with so briefly as to be not substantially dealing with it. That's explaining how his construction, so Lenovo's construction, worked with Claim 5. That's directed to a method which will be applied in a single TTI. He says that the position between and embrace a way that my Lord Justice Arnold put it, that it's all or nothing for each of us in the context of that 99 out of 100 debate, whether you could reverse the roles. But in Claim 5, there's just one iteration, one run-through, one TTI. It's all or nothing in the sense that it's run-through, just one run-through, and you either infringe or you don't. And as the judge held correctly, if you do it once, you infringe. And he didn't even try to address this in his submissions. He can't do so. He can't even point to the words in Claim 5 where he says his limitation doing it every TTI.
The argument is one of purpose of construction. He says the message from the specification is it's a universal rule if you've got to construe the claims, including Claim 5, in that.
Yeah, but he can't even point to words in Claim 5. He points to words in Claim 1, means for, and says it comes in there. And that's why, faced with that difficulty, he goes on the attack and says it's me writing words in the claim. A related point, and perhaps the last point, is this. The argument that my friend advanced that it can't be right to have it cover a system where you deliberately use more padding than the prior art 99 times out of 100, and therefore overall is worse than the prior art. You're using the method or the procedure 1 out of 100 on average. That, in my submission, is just simply the wrong way to look at it. Think about this. A car fitted with an invention for improving fuel economy doesn't avoid infringement if it's set up in such a way deliberately to operate much of the time without using the inventive part, say in a particularly poor way, worse than the standard prior art levels of fuel efficiency. If you do use the invention of the procedure in this case, just a small proportion of the time, each time you do, you're part of a population that is contributing benefit of the kind the patent gives you. And moreover, the apparatus with means that allow the procedure to be used for some of the time are able to do so, however small that proportion is. When you do so, you're part of the population contributing to that benefit. And it can't be right to say you avoid infringement by deliberately setting up the system to do something that's worse as regards padding for much of or even most of the time. What you're basically saying is, well, if I've got an apparatus that works in accordance with 2 different methods, if I make it so bad for the time that is not using the invention, I'm worse off overall. But of course, the time you're not overall better off, but you are better off than using the worst method all the time. You're kind of reining back the damage you do deliberately in the other side. It's just the wrong way to look at it, to say that I want to look at a system overall that does something different that's even worse, when you have got a period of time where you're using the invention and you're getting the benefit. And in any event, as I say, it's just simply not an argument that runs on Claim 5. Is there anything else I can assist you with?
Thank you very much, Mr. Speck. Well, we will go away and think about this. You will get draft judgments in the usual course. That's your opportunity to correct our spelling and grammar, but not our reasoning, nor to raise new points.
You understand?
The draft judgment comes with a strict embargo, which means what it says, so only those on the list that's been handed in before the case began will be able to receive
And
it.
these parties will know about the embargo, having just had a recent experience of it not being strictly observed.
Yes, we are very well aware of that model.
Right. We would hope that in the light of the draft judgment you will be able to agree an order disposing of the appeal, but if you can't, please make short submissions in writing and we will make the order that we consider to be appropriate. Thank you all very much for your help.
All right.